remember, whenever Seti Nash say something, what happens? A lot of people eventually have to join our bandwagon. So with that being said, Durk and them have a strong case to go ahead and get rid of the whole entire indictment. And it's not just Durk, it's everybody involved in the damn case. Check this out. This right here is why you have billion-dollar lawyer. This right here is what y'all been waiting for. And some people been saying it's like, yo, Nash, what do you think is going to happen with the stuff that they're already finding out? And I'm going to be fair. Everybody says the same thing. I don't know, because if I did, I'd be a billion-dollar lawyer. So let's get on with it. United States versus Durk, Banks, and all the defendants, basically. Notice of joint motion and joint motion to disqualify, dismiss indictment, vacate scheduling order, reopen pretrial hearings, and for an evidentiary hearing based on 5th and 6th Amendment violations. Defendant Durk, Banks, DeAndre, David, AUSA, by and through the respective counsel, hereby files this joint motion to disqualify all judges of the United States District Court for the Central District of California under 28 U.S.C. 455, disqualify the United States Attorney's Office for the Central District of California, dismiss the second superseding indictment with prejudice, vacate the scheduled order contained in docket 220, reopen pretrial hearings for an evidentiary hearing based on violations of defendant's 5th and 6th Amendment rights. Defendants request that the court follow the same procedure that the late Judge Manuel El implemented in United States versus Stewart. Y'all know we probably need to look at that before we even go forward. When presented with a similar motion, docket 47, upon receiving defendant's motion to recuse the entire court, Judge Real referred the matter to the Chief Justice. See also docket number 52, Ninth Circuit Order, under 28 U.S.C. 292B, designating district judge from District of Oregon to temporarily perform the duties of district judge for the Central District of California for the specific case, United States versus Stewart. This joint motion is based on the attached memorandum of exhibits and the files and records in this case, and any other evidence or argument that the court may permit. And you see they got everybody on this one right here. Notice of motion. This is where they basically gonna say, this is what happened, and then we're gonna go through it. But don't worry, we're gonna pop in and out on this one because lordy. And no, I'm not gonna read all 50 goddamn pages, but it is what it is. Defendant Durk, Banks, DeAndre Dontrell Wilson, David Brian Lindsay, and Asa Houston, by the respective undersigned counsel, hereby submit this joint motion to disqualify under 28 U.S.C., dismiss indictment, vacate schedule order, reopen pretrial hearings, and for an evidentiary hearing pursuant to the local rules the parties met and conferred on October 12, 2025, during which counsel for the government indicated that they opposed this motion. Of course they would. The government requires until December 1st, 2025 to respond to this joint motion, whereafter the defendants request until December 8, 2025 to reply. The parties request that the court refer this matter to an out-of-district judge for hearing as soon as practicable. So basically, a judge that was threatened was the one making the decisions. How that happens, I don't know, because some judges really believe, oh, I am not affected by this, but they used the whole entire case that was already done before, saying, yo, a judge already had a similar situation like this. This is what actually happens. The freaking, the feds are so scared now. They like, oh shit, no, push this, let's not hurry up and have this. No, let's not put a time, no, let's hurry up and go. You wanna know why? Because if everything that is said to the T in that last part is done now, they're gonna throw this damn case out. This looks insane. Basically, there's another similar situation. They already have another situation just like this. The case got dismissed. We need that same shit. Roll it. So here, the table authorities, they start going in, bro. When you start seeing, God dang, bro. When you start seeing all these statutes and all these prior cases that we can point to in situations like this, just know. And we're probably just going, I don't know, we're going to skim through this probably. But we'll see. If it just keeps on getting good, we'll have an hour-long video. It is what it is. Memorandum of Points and Authorities Introduction. For more than 7 months, the prosecution team concealed from defendants that both of the presiding magistrate judge and their lead trial prosecutor have received violent, case-specific death threats made while invoking the names of Durk Banks and DeAndre Wilson. This prolonged non-disclosure, compounded by undisclosed ex parte communications. Y'all remember ex parte in the YSL case with Thug and Woody and them, right? All right, cool. Between the prosecution team and the bench about these threats has irreparably compromised the structural integrity of these proceedings. By February 25th, 2025, at the latest, so they saying we don't even know when it began so far, the government and the district court knew that the Magistrate Judge Patricia Donahue had received 4 explicit voicemails threatening her life and courthouse personnel. On April 28, 2025, lead prosecutor AUSA Yanniello received similar death threats directed at him and all courthouse staff. The United States Attorney's Office, in carrying out a secret investigation, relayed the threats to all judges in the Central District of California. You gotta be kidding me. So, including this court. Yet, defendants learned nothing of these threats until October 1st, 2025, after months of litigation before judges who knew of the threats but remained silent, and just days before pretrial motions were due. Threats of violence against judges and prosecutors strike at the heart of our constitutional order. When individuals seek to intimidate those administering justice, they attack not just individuals, but the rule of law itself. And the undersigned and their clients unequivocally denounce these reprehensible threats against Judge Donahue, AUSA Yanniello, and courthouse personnel. The government's response to these threats, however, concealing them while continuing to prosecute defendants before judges who were themselves intended targets, violated fundamental constitutional guarantees. The prosecution's 7-month silence deprived defendants of their 5th and 6th Amendment rights to due process and an impartial tribunal. During this period, defendants unknowingly litigated critical matters, including detention proceedings and pretrial motions before judicial officers operating under the cloud of undisclosed threats. This concealment prevented defendants from seeking recusal, challenging the fairness of proceedings, or making informed strategic decisions. The resulting appearance of partiality, amplified by ex parte discussions between the bench and the prosecution about threats directly implicating defendants, has created an incurable breach of judicial neutrality that no less a remedy than a full recusal of the Central District Bench can cure. The integrity of criminal prosecutions depend on transparency and impartiality. Here, both were fatally compromised because these violations strike at the core of due process and the constitutional guarantee of receiving fair hearings in front of an impartial decision maker. Dismissal is the only adequate remedy. Additionally, the line prosecutors, especially AUSA Yanniello, must be barred from participating in the prosecution of this case, and because it appears the entire United States Attorney's Office for the Central District of California, USAO/CDCA, participated in the investigation, the entire office must be disqualified. Finally, given that the USAO sought a superseding indictment against the defendants just days after being directly threatened in their name, the indictment must be dismissed. The fact that USAO concealed the information and only revealed it to support its extraordinary motion to impanel an unanimous jury demands that the indictment be dismissed with prejudice. No lesser sanctions can restore public confidence in the fairness of this prosecution or cure the prejudice flowing from months of secret communications and judicial proceedings conducted under these extraordinary circumstances. To be honest, they should dismiss this. Not because, it's Team Durk or no shit like that. Y'all sent it to every damn judge. Niggas that wasn't even involved. The feds is dumb on this one. This gotta be one of the dumbest damn things I've ever read in my life. Y'all literally poisoned every damn judge. So imagine if you said, yo, Nash, I'ma beat you up. And I go, I'm scared, shit. But I lie, and I say to all my family members, yeah, he said he gonna whoop all of us. And so now when you walk around some of my family members, something that was just a conversation between me and you, everybody in my family tripping on you because I told them you said you gonna whoop everybody. Like, bro, I never said that shit. And that's wrong. The feds are, and this is the dirty game the feds play. This is like when y'all be like, oh yeah, and y'all push this bullshit that, oh, the feds have have a 90 whatever the hell conviction rate. That's propaganda. Y'all know we like to say propaganda over here. That's propaganda, bro, because at the end of the day, we really don't know. The feds play dirty, and I told y'all, they will hit y'all with like 47 damn charges. And then next thing you know, they drive it down. They get rid of a gang of charges. And next thing you know, you go, God, please send a miracle, please send a miracle, please send a miracle, please send a miracle against free will. Please do this against free will. And the feds come back and they say, you know what, instead of those 47, we're gonna drop it down to 17. And you go, hot diggity damn, y'all got me on something. And then the fact that they kept on pushing this, and we kept on, and everybody kept on sitting like, hey, bro, you do know that if these cats are making threats like this against judges and lawyers and all this shit, bro, we do know, right? We must know who it is, so y'all get on and investigating. It wouldn't surprise me if the feds were the ones making this goddamn call. It wouldn't surprise me. I'm not saying that they are, because that'll be lying, and I know they'll be knocking on my door. But it wouldn't surprise me if the feds are the ones who made up the damn calls, or if the calls even exist at all anyways. Hell if I know. But if somebody actually did make these calls, your ass going to jail forever. Let's go. This just gets crazier. I'm about to damn read. Factual background. By at least February 25th, 2025, the prosecution team, including the lead FBI case agent, Sarah Cochran, and the USAO, knew that Judge Donahue had received violent threats connected to this case. By April 28, 2025, they also knew that AUSA Yanniello and courthouse USAO personnel have been similarly threatened, yet the government did not disclose any of this to the defense until October 1st, 2025. As more fully detailed in the paragraphs below, the most relevant dates to this joint motions are as follows. February 22nd, 2025, 4 threatened voicemails to Judge Donahue referencing Mr. Banks and threatening Judge Donahue and courthouse personnel. February 25th, 2025, USMS contacts Chambers and USAO FBI opens investigations. SA Cochran becomes FBI point of contact and actively investigates threats. April 28, 2025, threatening call to AUSA Yanniello with death threats to AUSA Yanniello and courthouse USAO panel. May 1st, 2025, the United States Attorney's Office obtained a second superseding indictment, in this case docket number 147. May 8, 2025, detention hearing before Judge Donahue. Threats still undisclosed to defense. June 2nd, 2025, detention hearing and pretrial motion hearing on defendant's motion to disclose grand jury transcripts before Judge Fitzgerald. Threats still undisclosed to defense. Continued detention ordered. Ruling pending on motion to disclose August 6th and 13th, 2025. Conferences between prosecution team and undersigned defense counsel, RE, anonymous jury, threats still undisclosed. October 1st, 2025. First pretrial disclosure of threats by government. The defense makes oral demands for immediate disclosure of all relevant materials and communications about threats. October 9th and 14th, 2025. Defense written discovery demand letters. October 23rd, 2025. Government's letter and selective disclosures about threats. Threats directed against Magistrate Judge Donahue and courthouse personnel. On February 22nd, February 22nd, 2025, a mail caller left 4 violent voicemails for Magistrate Judge Patricia Donahue on her work line. Exhibit 1, declaration of Jonathan M. Brayman. The messages referenced Mr. Banks and Mr. Wilson by name, contained explicit death threats and invoked acts of mass destruction, accompanied by sounds mimicking gunfire. You gotta be kidding me. I'm the judge. I'm strapped up. I come get some. But shout out to that judge. Special Agent Cochran, FBI, FD 1057, detailing death threats received by Judge Donahue, left on her work voicemail on February 22nd, 2025. Transcribed February 22nd, 2025, death threat voicemails under seal. For example, one word warning: if they get life, I'm going to burn this shit down. I'm talking about the world. And I'm going to burn it down. I'm going to burn it to the ground. Nigga, I would have rolled my eyes to the back of my dome. On the voicemails, the caller urges Judge Donahue repeatedly to do the right thing and to free Mr. Banks and Mr. Wilson. The government's immediate awareness and proactive investigation into the February 22nd, 2025 death threats received by Judge Donahue. By February 25th, 2025, the United States Marshal Service, USMS, had contacted Judge Donahue's chambers and the USAO regarding the threats. reports and emails between prosecution team, USMS, and the judiciary. The FBI opened a criminal investigation and assigned Special Agent Sarah Cochran, the lead case agent on the bank's prosecution, as a primary point of contact. Cochran drafted the FBI FD 1057 report describing the voicemails and was listed as the contact person for the investigation. Agent Cochran and the USAO coordinated investigative steps, including full workups on the suspected caller, cross-check of jail and call records, and communication with other field officers. She also arranged for the FBI to interview the suspected caller and reported the results to the AUSA's and USMS reports and emails between prosecution team, USMS, and the judiciary filed under seal. Thus, by late 2025, both prosecution team and the bench were aware that the magistrate judge presiding over the case was named victim of violent, case-specific threats, additional threats against AUSA Yanniello and courthouse USAO personnel on April 28, 2025. A separate caller telephoned AUSA Ian Yanniello at the AUSAO issuing explicit death threats against him, as well as everyone who worked at the courthouse and the USAO. Special Agent Jordan Guyton, FBI FD 1057, detailing death threats received by AUSA Yanniello at the USAO via telephone. Agent Guyton's FBI report is dated approximately 2 full weeks after the threatening phone call that AUSA Yanniello received. Because it was not produced in a discovery produced by the government on this issue, it is unknown to the defense what reason explains this delay, nor does the defense have any information about what happened immediately after AUSA Yanniello received the phone call. Many questions remain unanswered from the government's discovery production. For example, did AUSA Yanniello first call his supervisor? Did he call Agent Cochran? Who took the initial report? Did agents listen to the recorded call? Has it been preserved? Did AUSA Yanniello have communication with the court right away? Who did he talk to? What did he say, if anything, about the phone call's relationship to the defendants? The discovery produced shows that the prosecution team and the lead case agent, FBI Special Agent Sarah Cochran, played an active role in the investigation into the death threats received by AUSA Yanniello, reports and emails between prosecution team, USMS, and the judiciary. And perhaps most critically, an evidentiary hearing could answer how it is that the grand jury returned a second superseding indictment charging an entirely new charge, stalking resulting in death violation 3 days after the lead prosecutor's life was threatened by people purportedly seeking to free the lead defendant. Did the threatened telephone call to AUSA Yanniello have any impact on the government seeking additional charges? Did the threatening phone calls to Judge Donahue have any impact on the government's efforts to further indict? What, if any, of this was shared in ex parte communications between the court and the government? The discovery leaves these questions unanswered, and because the defense and public were kept in the dark about the threats investigations and any potential impact it may have had on the bench's impartiality, the court should order further inquiry. The FBI later determined that the caller was a different individual than the one who called Judge Donahue and made death threats, and that a full investigation was opened pursuant to Section 7.5 of the FBI's Domestic Investigations and Operations Guide, cited potential violations of 18 U.S.C. 875C. This was to be the second full criminal investigation opened by the FBI regarding threats the bench and government received related to the instant prosecution. Both call incidents were referred for criminal investigation. The FBI investigation into the death threats received by Judge Donahue had an FBI case ID number of 89B LA 404-5113, and the FBI investigation into the death threats received by AUSA Yanniello had an FBI case ID number of 9E LA 407-4487. Moreover, the prosecution team, through case agent Cochran, initiated investigations into both sets of threats by FBI's Joint Terrorism Task Force and the FBI's Guardian Squad. Special Agent's FBI Guardian Complaint Form 71 from Judge Donahue threats investigation. Special Agent Cochran's FBI, this is just going too much. Continue litigation before threatened judges without disclosure. How is it that y'all getting all of these threats? Y'all tell us nothing. So now we sitting up here in the blind. And on top of that, bruh, is this even real? Is this even true? Is this the reason why y'all start going so hard and basically trying to do all of these things? And it's funny because they're trying to paint Lil Durk as this mastermind with connections of people who will hurt you because you're technically going against him. This is all a part of the messaging they're trying to push. And this is why it's so important that they do this stuff. They know they don't have a case. They know they don't have a real case against Lil Durk. Everybody else, shit, they might be gone. But I'm going to say this, and I'm going to make this emphatically clear. If there is some idiots out there really doing this, bro, the feds are going to fry you worse than goddamn eggs. If you are one of them, you got to be one of the dumbest individuals to threaten a judge, then threaten a goddamn lead attorney. With all due respect to everybody, I hope they catch you. I hope the feds catch you and stretch your ass out like Laffy Taffy, because you gotta be one of the dumbest idiots. Lil Durk team should be thanking you, honestly. And why should Lil Durk's team be thanking you? Because who the hell would be so damn stupid? This is, bro, whoever did this shit, you going to hell on earth. The feds gonna fry you if they didn't already catch it. I ain't read this whole indictment. You guys are reading it with me. I just found this out like late, but yeah, for the feds to sit up here and have all this information and this extra fire and basically keep on pressing and keep on pushing shit like lyrics that did not even occur. So yeah, bro, I ain't gonna hold you. So far, so good for Banks and this whole entire team. Let's continue on to the Batmobile. Continue litigation before threatened judges without disclosure. Despite this knowledge, the government did not disclose the threats to the defense while the case proceeded before the very judges implicated. Judge Donahue presided over Mr. Banks' May 8, 2025 detention hearing. Months after receiving the threats, at the hearing, Judge Donahue heard evidence from Mr. Banks, considered the arguments and counter evidence presented by the government, and ultimately denied Mr. Banks' pretrial release from custody on the grounds that he was both a risk of flight and, more salient, for purposes of this motion, a danger to the community. No shit, you got threatened, so it would only make sense that he would be a threat to the community, right? To state the obvious, Judge Donahue was in no position to consider whether Mr. Banks was too dangerous to be released while having been both personally threatened by someone purporting to act on Mr. Banks' behalf and having had her entire workplace physically and violently threatened by the same. And not once did she reveal this potential for partiality and conflict to the defense, or put the matter on the record for the good of the public's faith in the impartiality of the proceedings in any way, and the discovery fails to elucidate why this is so, further necessitating an evidentiary hearing as to ex parte communications between and among the bench and the prosecution team, leading to this unusual outcome. As the court is aware, Judge Donahue denied Mr. Banks' bail request on May 8, 2025. Mr. Banks then appealed Judge Donahue's detention order to Judge Fitzgerald. The government filed an opposition to Mr. Banks' appeal of the detention order, docket 167, on June 2, 2025. Mr. Banks and Mr. Wilson appeared before Judge Fitzgerald at a hearing on the appeal of the magistrate judge's detention order on their motion to produce grand jury transcripts. Neither before, during, or after that hearing did Judge Fitzgerald disclose that he was aware of the threats, investigations against his colleagues, his courthouse, or counsel for the government. And because he did not make that disclosure, Judge Fitzgerald did not assure Mr. Banks or the public that those pending investigations and ex parte communications had any bearing on his view of Mr. Banks standing in the case, his request for release, and any future proceedings before him. Rather, on June 9, 2025, Judge Fitzgerald simply denied Mr. Banks' appeal of Magistrate Judge Detention Order, docket 202 at 4. Magistrate Judge correctly determined that clear and conceiving evidence supports the finding of danger. And as Magistrate Judge concluded, defendant uses his money, influence, and power to endanger individuals whom he perceives as a threat. That's a hell of a way to say that. Throughout the spring and summer of 2025, the parties engaged in extensive pretrial litigation and trial preparation, including discovery, disputes, and conferences about the government's intention to seek an unanimous jury. During the August 6th and 13th meet and confers, the government invoked generalized safety concerns, but again failed to reveal the death threats and the existence of criminal investigations into the threats against the presiding judiciary and the prosecution team. Remarkably, during the August 13th meeting conferred, in response to defense counsel's inquiry whether the government's request to impanel an anonymous jury was the result of a particularized concern for safety. In this case, AUSA Yanniello, who himself had been the target of violent threat purportedly made in relation or on behalf of Mr. Banks, responded that he was confused by defense counsel's question given the obvious safety risk. What? What the hell you mean obvious if we didn't know? Associated with the violent nature of the charges in the pending prosecution, never in the August 13th phone call did AUSA Yanniello or his colleagues disclose the existence of threats or the pending criminal investigations into threats. This is especially egregious when just weeks earlier, the AUSA On the case, requested that the defense enter into a stipulation waiving any efforts to recuse Judge Fitzgerald given his brother's employment at the U.S. Attorney's Office during the pendency of this case, that the government would seek to exact a recusal waiver on a de minimis issue of judicial neutrality while concealing the existence of the threat investigation and the possible effect on the bench is deeply troubling. Because how in the hell can you say, hey, you know it's obvious safety concerns here, and we're like, nigga, what the hell are you talking about? That's insane right there. The government's selective, limited, and untimely disclosures followed by defense demands. I'm sorry, y'all, about the AC, but I'm on vacation in Puerto Rico, bruh, and it's hot as hell out here, so I got to keep that AC on. Sorry, y'all, for the noise. But only on October 1st, 2025, just days before the deadline for filing pretrial motions, did the prosecution partially disclose that Judge Donahue and AUSA Yanniello had been victims of threats regarding this case. Defense counsel for Banks, Wilson, Lindsay, and Houston immediately demanded complete disclosure of all related communications, investigative reports, and correspondence between the USAO, FBI, USMS, and the bench. On October 9th and 14th, the defense memorialized those demands in writing. See Group Exhibit 1, Declaration of Jonathan M. Brayman. The USAO responded on October 23rd with its own letter. The government's October 23rd letter completely ignores or minimizes several important events, including, we're not going to go through all this stuff. They just saying the exact same shit that they wrote. The argument and legal standards governing disqualification and recusal. You know, it's crazy. They were just acting like, you know, he's a bad guy. And they was like, well, if he's such a bad guy, why'd y'all create a second superseding indictment instead of the first one? The first one saying that, oh, there was money involved and all this other crap, but then turn around and then you say this shit randomly. In my mind, if I'm a lawyer, I'm thinking, why are you saying this? And they kept that in the back of their head until this came out. So for the feds to be like, yeah, he's a bad guy, and them cats looking around like, nigga, you ain't got no slam dunk case, bruh. I don't know, bro. The feds have always been dirty, always been slimy. Our country, because of its greatness, we poison other countries. Like, we go after other countries. You think we won't use these same tactics in the same courtrooms that's used to lie on justice every single day, Monday through Friday? Come on now. Now, let's not pretend that, you know, there ain't some evil, sick bastards out there. That's very true. And I'm going to be fair, square, obvious, and honest. We do need what we have, but also you need attorneys like Drew Finland. So enter this code right here, Sadie Nash, number 1, and get $20. I'm just messing with y'all. He's about to put in a promotional code to use Drew Finland and get 20% off. Nah, but yeah, bro, the feds are looking pretty damn dumb, because how do we know that Drew and them would have a freaking bounty on their head either? Like, yo, and tell Drew if he loses his cases, we gonna offer his head too. So it's just shit like this where it's like, you can't be a person who's been threatened and then make decisions as well. Get out the way. Just those decisions, bruh. It's just those decisions. Like, the damn judge snitched on herself. The judge snitched. Said, oh, yeah, with obvious threats to witnesses and everybody else. Obviously, to who? Oh, to you, because it happened to you. And that's why they use the damn word influence. And that's why they are actively trying to, and I kept telling y'all, bro, to the Dede murder shit, bro, like, why are they constantly trying to bring this in when Illinois said Durk had nothing to do with this shit? Why are they constantly doing this shit? I kept asking this question to everybody. Nobody acknowledged this. Let me know in the comments right now if you get what I mean when I say, bro, why the hell were they bringing in this case when Lil Durk had nothing to do with it? Oh, because his presence, his name will invoke you to do evil. It's like yelling out Shaitan. Hey, if you yell out Shaitan, it might become a part of you. Who knows? Crazy shit. Let's continue on. And this will be the last thing that we read. I know it's been a long video. Y'all probably on the edge of y'all seats. Like, thank guys you turned out the damn AC. I know it's loud as hell, so my bad for that. Anyways, argument. Legal standards governing disqualification and recusal. Standard for judicial recusal. The principles at stake here are fundamental. The Fifth Amendment guarantees criminal defendants a fair and impartial tribunal. The Sixth Amendment guarantees a fair trial. These rights are codified in 28 U.S.C. 144 and 455, which collectively require recusal whenever a judge's impartiality might reasonably be questioned, or she has personal bias or prejudice or personal knowledge and dispute evidentiary facts. As the Supreme Court has cogently put it, the purpose of these statutes is to avoid even the appearance of partiality. If it would appear to a reasonable person that a judge's knowledge of facts that would give him or her an interest in the litigation, then an appearance of partiality is created even though no actual partiality exists, because the judge does not recall the facts, because the judge actually has no interest in the case, or because the judge is pure in heart and incorruptible. Yeah, bullshit. The demand recusal even when no actual bias is shown. The appearance of partiality is enough. And that is true. That's very damn true. Section 144 provides a procedural mechanism for disqualification based on actual bias. It requires a timely and legally sufficient affidavit showing that judge has a personal bias or prejudice against the party, even where an affidavit under 144 is found procedurally deficient. The same facts must still be considered under 455, which imposes an independent self-executing obligation on judges to recuse whenever their impartiality might reasonably be questioned beyond the bench. The same constitutional principles apply to the prosecution. Due process forbids the government from maintaining conflicts of interest or engaging in conduct that undermines the neutrality of the proceedings. Young versus U.S. The Ninth Circuit has made clear that disqualification of an entire United States Attorney's Office is an extraordinary remedy, appropriate only when the most exceptional circumstances. United States versus Williams. Under Williams, such a remedy requires a strong factual predicate demonstrating that the conflict or misconduct is institutional rather than individual. And that's very damn true, because y'all spread this shit to all the judges. And two, a showing that the office's continued participation will result in an actual legal or ethical violation or otherwise compromise the fairness or appearance of fairness in the proceedings. Court cautioned that because the separation of powers concern inherent in judicial oversight of the effective branch, office-wide disqualification should be ordered only when lesser remedies, such as recusal of individual prosecutors or internal screening, will be inadequate to eliminate the conflict. At bottom, the inquiry under 455A and due process clause asks whether a reasonable or prudent person, knowing these objective facts, would harbor doubts whether the court is impartial. The threats and ex parte communications require recusal of the Central District of California bench. The appearance of partiality is sufficient. And they really have that, bro, because once again, the damn DA decided we're going to give this shit to all the judges to let y'all know y'all homeboy got threatened. You think if you threaten my homie that nigga, I'm not going to whoop your ass too? Come on, bro. Reasonable thoughts. Magistrate Judge Donahue was named victim of 4 recorded death threats that referenced Mr. Banks and Mr. Wilson by name. She presided over detention hearings, heard argument from counsel, and issued rulings in the weeks and months following those threats. Judge Fitzgerald later reviewed and relied on those rulings. Neither made any disclosure to defendants about the threats, even assuming the judge's actual impartiality. The appearance of impartiality has been lost, and that's very true. As the Supreme Court recognized in Lilleberg, recusal is required where an objective observer would have reasonable grounds to question the judge's impartiality. Moreover, the pattern of non-disclosure and ex parte communication over a period of 7 months undermines both the appearance and the reality of fairness. Courts have long recognized that when threats to a judge are credible and not contrived by the defendant, recusal is required to preserve confidence and impartiality. Those cases, and Holland itself, distinguish between self-serving threats intended to manipulate the system and genuine external threats that create an appearance of bias beyond repair. Where the latter exists, as here, recusal is mandatory. Here, any reasonable observer would doubt the fairness of proceedings in which a magistrate judge, while being investigated as a victim of threats referencing a defendant by the prosecution team, continued to make critical pretrial rulings, and where the district judge later adopted those rulings without disclosure to the defense. The Ninth Circuit's decision in United States versus Holland does not excuse the failure to recuse here. If anything, it underscores why recusal is compelled. In Holland, the defendant himself had personally obtained the sentencing judge's home's telephone number and left a threatening voicemail before sentencing. The district court revealed the call on the record and characterized it as an obvious attempt to manipulate the system. On appeal, reviewing only the plain error because no recusal motion had been filed, the Ninth Circuit affirmed, emphasizing that threats do not automatically require recusal where they are transparently manipulative, unserious, or intended to game the system. The court explained that recusal under 28 U.S.C. 455 depends on both an objective appearance test and a subjective bias test. The judge must recuse when a well-informed, thoughtful observer would perceive a significant risk that the case will be decided on a bias other than the merits, or when the judge personally concludes he cannot be impartial. The Ninth Circuit warned that judges must guard against letting defendants weaponize threats to obtain a new jurist, but also acknowledge that there where credible threats exist, or where the appearance of partiality becomes unavoidable, recusal is required. The circumstances here bear no resemblance to Holland. First, the threats in this case were not made by any defendant, by the outside individuals invoking Mr. Banks' name and threatening the lives of the magistrate judge, the lead prosecutor, and everyone who worked at the courthouse, and the USAO CDCA. There is no suggestion of manipulation by the defense and no conceivable initiative to create such threats for tactical advantage. Second, unlike in Holland, where the judge deemed the threat trivial, made no referral to law enforcement, and proceeded after open disclosure, the threats were taken with utmost seriousness by the government itself. Within days, U.S. Marshal Service and FBI launched a full investigation under Section 7.5 of the FBI's Domestic Investigations and Operations Guide, the same FBI case agent leading this prosecution. You gotta be shitting me. Special Agent Sarah Cochran was designated as the point of contact for the threats investigation, prepared FD/1057 reports describing the threats and coordinated with multiple agencies. The USAO CDCA was directly involved throughout. That multi-agency response demonstrates the government's own recognition that these were not empty or manipulative gestures. They were credible threats that triggered sustained federal law enforcement involvement. The third and most critical distinction in disclosure in Holland, the district court disclosed the threats before sentencing, allowing the record to be clear that, in adversarial. Here, the government and judiciary concealed the existence of the threats for more than 7 months. Such communications violate both 455B1, personal knowledge of disputed evidentiary facts, and the Code of Conduct for United States Judges, Canon 3A4. The Ninth Circuit has long condemned undisclosed ex parte contacts between the government and bench on matters bearing on the merits of a criminal case. But here, for months, the magistrate judge, who had been named the victim of threats, presided over Mr. Banks' detention hearings and issued rulings that the district court later adopted. Meanwhile, the prosecution team, aware and participating in investigations, conferred privately with chambers and court security about the same threats, but never disclosed them to the defense. Only on October 1st, 2025, did the government finally reveal that both the judge and lead prosecutor had been targeted. That prolonged non-disclosure and the pattern of ex parte communications it reflects create precisely the appearance of impropriety that 455A was enacted to prevent. This distinction between trivial, self-serving threats and genuine, externally generated ones is precisely what other circuits have found determinative in United States versus Yusuf. The Second Circuit explained that recusal was required where a reasonable observer could question whether a judge who has been the target of a genuine threat could remain entirely impartial, particularly when the threat arises from sources beyond the mere defendant manipulation. Similarly, the 10th Circuit had consistently held that genuine threats compel disqualification to preserve both the reality and appearance of justice. In Nichols versus Alley, United States versus Greenspan, recognized that when threats are not contrived by the defendant, but instead appear credible to provoke a legitimate security response, recusal is necessary to avoid an appearance of partiality that reasonable members of the public could not ignore. These cases, read together, make clear that the duty to recuse turns not on the judge's subject sense of safety, but on whether a reasonable observer would doubt the judge's impartiality under circumstances. Under Holland's own framework, recusal is mandatory, and every objective factor supports recusal. A reasonable observer, knowing that the presiding magistrate judge was the victim of a credible threat under active FBI investigation, that the prosecutors were simultaneously litigating before her while communicating privately about the threats, and that the defense was kept entirely in the dark, would unreasonably harbor serious doubt that justice could be seen to be done, even assuming the judges themselves sincerely believe they can remain impartial. The appearance of impartiality is gone. As Holland itself recognized, credible threats create two unacceptable risks: that a judge will unconsciously temper rulings to diffuse danger, or conversely, that the judge will overcorrect by favoring the government as a means of asserting control or deterrence. Both possibilities erode confidence in the fairness of the proceedings. Unlike in Holland, where a single defendant manipulated call was dismissed as unserious, this case involves third-party threats so grave that the federal government launched a full criminal investigations. Those circumstances, compounded by 7 months of secrecy and ex parte communication, go far beyond what Holland tolerated. They strike at the structural integrity of judicial process, and compel recusal of the affected judges and reassignment of the case outside the Central District of California under Yusef Nicholas Greenspan Cooley. Recusal is not optional. It is necessary to preserve both due process, the integrity of the proceedings. The government's failure to disclose threats and resulting criminal investigations require disqualification of the USAO CDCA. From February through October, the United States Attorney Office for the Central District of California knew that both the presiding magistrate and the lead prosecutors were the victims of violent threats made in apparent support of Mr. Banks and Mr. Wilson. Despite the knowledge, the office continued litigating this case before those same judges, relying on their detention rulings, conducting discovery conferences, and engaging in ex parte communications regarding courthouse security without ever disclosing the threats to the defense. The result is an irreconcilable conflict of interest. The lead prosecutor, AUSA Yanniello, became both victim and a participant in a criminal investigation closely tied to this case, while his office continued to prosecute it. By proceeding without recusal or disclosure of the inherent potential conflicts, the USAO effectively blurred the line between advocate and witness, compromising both the independence of the prosecuting authority and the integrity of the judicial process. This was not a run-of-the-mill discovery dispute. The information that the government intentionally and actively withheld from the defense dealt with the very integrity, neutrality, and fairness of the proceedings. The death threats. Let's just go ahead and go down and see what the hell they finna say. Because they just basically gonna say, dismiss this whole entire shit. Because now they're just like, it's word salad at this point. They keep on saying this. The extraordinary circumstances here meet and exceeded the Williams standard for office-wide disqualification. The conflict is not confined to one AUSA, but pervades the entire USAO CDCA, which functions simultaneously as victims, witness, investigator, and prosecutor. Under these conditions, no lesser remedy, whether screening individual prosecutors, substituting personnel, could restore public confidence, or ensure fairness. The Department of Justice can assign this prosecution to another district. Only full disqualification of all of California, basically, can remedy the appearance of improperty and assure the defendants and the public that this prosecution will proceed free from bias, conflict, and the lingering shadow of concealment. So yeah, we're not gonna keep on reading this shit because they're just basically going on to say the same damn thing. But let's get back into it.
You know what's crazy is in July, years ago, we had gone viral for the first time, something that we said about Banks, well, about Lil Durk and somebody breaking in his house and all this shit, and how was somebody in OTF. That later got revealed. This one right here is going to work. They're going to toss it to another district. They can't do it in this one. They can't. It's impossible. You can't sit up here and say, yeah, we all got threatened, all of us. Spread it to all the judges in Central District of California, and then say, I'm gonna be honest, we can still do our jobs after we got threatened. No, because a reasonable person, meaning you, yes, you watching, you individually or a group. Some of y'all be watching with y'all girls. Some of y'all girls be tapping. Stop doing that too, because some of y'all men be in my inbox like, bruh, hey, knock you out, you cop my girl inbox. But anyways, a reasonable person would say, there's no way in hell no judge can be unbiased from this. So when they say reasonable, they're saying you, regular individual like myself. There's no way in hell. You can't threaten me and then think I won't hold it against you. And then say little hints like, yo, it's obvious that this person is dangerous. Oh, obvious security risk. What obvious security risk, bitch? What you talking about? The feds are dirty. And I ain't gonna hold you. It's gonna there's no way in hell. There's zero, a big old zero. There's zero way in hell this don't get kicked off to somewhere else. Because they're not gonna dismiss the whole entire case. They're not. They're just not. So where it goes, hell if I know. It probably goes up to Oregon. If it go to Arizona, bruh, I ain't gonna hold you. Shit, y'all might want to get it back to California because California is liberal as hell. Like, they will hear these lyrics. Like, the white people we have in California is better than anywhere else. I'm sorry. We got the best blacks, we got the best Asians, we got the best damn Hispanics, and we 100% got the best white people in California. Hands down. Why? Because they grew up on gangster rap. They grew up on Snoop Dogg and Dr. Dre and Eazy-E. They grew up on Ice-T. They grew up on Ice Cube. They grew up on NWA. They know what F the police means. They know that it's not a violent goddamn song. They witnessed the Rodney King riots and all of this shit. And we're talking about the older ones. So, shit, we'll see what happens, bro. But right now, as it stands, this case is done in California. Sure to keep your people aware, subscribe, turn on bells to notify. Click right here to see how Jim Jones' ass is up there sounding like Lil Meech in the goddamn airport, bro. Pathetic. Click right here, or click right here for the playlist. I'm on vacation, so the video is probably gonna slow up, man. I'm sorry I had to get out the house, but hopefully I can still maintain. I'll catch you on the next one.